Yes, good evening. Welcome to another daily dose of SirToshi's news. Today's date is Monday, the 9th of October 2023, the year of BSV. Buy BSV.live, the best place to buy Bitcoin SV online, the original protocol and genuine Bitcoin. Let's get into it. Right, so today we are talking about the law and what is going on in court and everything else like that. So this was a post from Diego. This was related to the Bitcoin copyright of the Bitcoin file format. I think he's got this piece from here, which is Dr. Craig Stephen Wright versus Ors versus BTC Core and Ors. And the date here is the 7th of February 2023, so this might not be recent. But there is a passage that I found in his post, which I've highlighted here. So we'll just go through this. This doesn't sound too positive, but I'm gonna put my take on it. So this was he says this was Copa versus Craig Wright. Mr. Justice Meller, maybe the link isn't correct, but who knows. But the first bit is very, very positive, where point 50 is stated where there are a number of points made in the council's submissions with which I have no difficulty whatsoever. Indeed, each of the following points I have already assumed in Dr. Wright's favour, either explicitly or implicitly. Number one, that Dr. Wright expended substantial skill and judgment in creating the Bitcoin file format. So he's already said that he created the Bitcoin file format. How crazy is that? Such that the originality / intellectual creativity requirement is met. In other words, I've ignored any potential issue as mentioned by Arnold J in SAS number 3 at 41, whatever that is. And number two, that Dr. Wright devised and created the Bitcoin file format with course of writing the code for the Bitcoin system. I mean, this is nuts. He's already either explicitly or implicitly assumed in Dr. Wright's favour. I mean, that is insane. That is insane. And number three, whether there is no reason why two works cannot be created in parallel with one another and in the course of the same creative process. So again, this is where it just starts to get a little bit iffy. And then he starts going on about, he says, where I part company with the claimants, and again, this is Dr. Wright, is with the final submission that the requirement for fixation / sufficient identifiability was met automatically when the program was run. You know, blah 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 blah. You know, it carries on. There's quite a lot mentioned here. I'll see if I can find the bit where it got my attention. 59. He says, I also observe that it is not at all surprising that a block does not contain content, whether flags or symbols, which indicate the structure. Not only would they be unnecessary, their inclusion would also be a very inefficient use of money. And 60, Mr. Hicks' final submission was to the effect that A, the law in relation to the copyright in the file format is still developing. Well, not really. And B, it remains arguable that copyright did subsist in the Bitcoin file format. So arguable whether or not it did actually exist or not. So let's just go back to point 58. It is also highly pertinent that the claimants, as in like Dr. Wright, did not file any evidence to the effect that my rather basic understanding of the opinion as regards to a block and the understanding set out in the quote under paragraph 10 above was incorrect. I'm driven to the conclusion that there are no overt signs in a block which indicate the structure as described in Schedule 2 of the particulars of the claim. Akin to the conclusion set out at the end of 128 in SAS number 3, there is no evidence that the Bitcoin file format is set out in any part of the software or early blocks written to the Bitcoin blockchain, as opposed to the Bitcoin software simply reading and writing files in the format. Now, again, I might be interpreting this wrong, but when he's saying, there is no copyright with regards to the Bitcoin file format. So this is where the lawyers have to point out that any changes to the protocol, which also includes changes to the structure of the blocks, particularly in the fact that digital signatures are attached or built in to the to the transaction data, and also how the order in which the data is uploaded. In order for it to be a commodity, the order in which the data is uploaded has to be in time order. So in terms of what they've done with BCH, they've used canonical transaction ordering, which actually rearranged the order in which the data is uploaded into the block. If the data is rearranged, if it is changed, if it is not uploaded at the precise time that it was actually broadcast to the network, it means there is a third party changing the order of it, which means there is a third party controller because data is not in the order that it was uploaded to. And again, this is to do with keeping the network as a commodity network. So if they change the file format, which is the protocol, by segregating the digital signatures from the transaction data, or rearranging the order in which data is stored within a block, you have a third party controlling it. And when you have a third party controlling something like that, it means you securitize it and you remove all economic value and contractual credibility from the network. So it's not really a point of copyright. That particular argument there should be about the economic argument of keeping it as a commoditized network. That's my that's my take on that. So I thought I'd talk over that. And here's that sentence in point number 58. There is no evidence that the Bitcoin file format is set out in any part of the software or early blocks written to the Bitcoin blockchain, as opposed to the Bitcoin software simply reading and writing files in the format. Yeah, again, so this is to do with the economic argument and contractual credibility argument, rather than a copyright argument. That's my personal point of view anyway, from my interpretation of it. So let's move on. So Diego doing a fantastic job reporting on all of this. So he's just said here on this post that was posted earlier today, said breaking: Craig Wright changes legal representation in the Copa versus Wright case. He's now represented by the mighty Shoesmiths law firm, known for their work with Mercedes-Benz, Marston's and Travelodge to Octopus Ventures, majority property developers and some of the UK's largest banks. We work with a growing number of FTSE 250, that's FTSE 250, and some of the world's most exciting and ambitious growth businesses. They've also been recognised as the market leader in Legal Business Awards 2023 by Technology Consultants. So it's just got here added Craig Stephen Wright, Shoesmiths LLPs, Wright Internationals, Shoesmiths LLPs. Just got a brief image of Shoesmiths there and their logo, representing Craig. So just go on to Calvin's tweet here. So this is also posted on October the 8th. Calvin said, me wanting Craig to sign for Copa means that I know he is Satoshi. Well, again, signing is not proof of ownership, so you're not actually proving you're Satoshi. It's just proving that you actually have the keys. This is nothing to cheer about by those who want to spread tears. He is also the world's top enterprise blockchain expert, something crypto sorts do not even understand. So again, I mean, Calvin is saying that he wants him to sign. Again, as Craig has said over and over and over again, possession is not proof of ownership. It doesn't matter if he signs. It's just that the other side want him to sign in order to pop the bubble, and then everyone's going to be pointing at him going, oh, it's your fault that I've lost billions of dollars. You could have proved that you were Satoshi prior to that. Well, that is just it's a terrible idea. It's a terrible idea. Craig cannot be seen to be popping this bubble. It has to be a judge's decision to prove that he is Satoshi Nakamoto. Or it has to be the miners realizing this. It cannot be him, and I'll explain that later. So this is Shoesmith, so just wanted to go over that. So on their website it says blockchain and digital asset compliance, blah 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 blah. I always get a little bit reserved when I hear solicitors going on about finance and Bitcoin, because Bitcoin's a commodity and I don't really get this. So they said financial services sector clients at Shoesmiths include crypto assets. Again, it makes me shiver whenever I hear the word crypto assets. Market participants, crypto asset businesses, and relevant service providers. Again, they're just it's just fronting. They're trying to give the impression that they actually know what they're talking about, when in actual fact they don't actually have a clue, because they don't get how Bitcoin is a commodity. No one does. In fact, I don't know anybody who can explain how Bitcoin is a commodity, apart from how I've done it in my recent article about how the protocol was actually built into Bitcoin, but it's hidden in the white paper. It's those 5 points. So anyway, they said what differentiates Shoesmiths from other legal providers is a recognition that each element, asset class and technological application in the sector is unique and demands input from various and different specialists. It is a multifaceted, see, when they use words like multifaceted and all this kind of crap to hide the fact they don't really know what they're talking about, doesn't fill me with confidence. A multifaceted area which permits Shoesmiths to deploy its specialist team, providing clients with the most efficient advice in the most efficient way. UK regulators are in the process of attempting to clarify and develop the current regulation of digital currencies within the UK. Again, they're using the word digital currencies. It's not currency, it's money. There's a big difference between currency and money. They're literally like night and day and chalk and cheese. And its potential impact on firms and consumers. As more mainstream financial services firms enter the market, innovation in this area continues to accelerate. Well, not really, because we've seen the amount of crap that's going on. It's outrageous. And those in the financial services sector who have exposure are becoming more concerned about scope and application for a regulatory perspective. Regulation already exists. It's got nothing to do with securities. It's got nothing to do with the SEC. It is purely a commodity, which means it falls under the CFTC. But then if somebody created it, which somebody created all cryptocurrencies, then it falls under the SEC. So again, they're not differentiating Bitcoin from all these shitcoins and these other cryptocurrencies. So they said our team will assist on whether activities in the crypto and broader fintech sectors are regulated by the Financial Conduct Authority, Financial Services and Markets Act, or other legislation, and any other applicable guidance. We are also able to help you with any applications for regulatory permissions under the UK regime. Again, that word sends shivers down my spine. And provide an ad hoc advice on marketing crypto assets. Again, they're using the word crypto assets. Oh my God. So all crypto assets are securities. That's it. Bitcoin is literally the only commodity, because data can only be commoditized one way. And then here they're going on about AI and distributed ledger technologies and all this. Just doesn't fill me with confidence at all that they actually know what they're talking about. It just looks like bravado to me. So the reason I want to talk about this and actually reach out to Craig and Enchain and CoinGeek is because changing solicitors at the last minute and using a law firm, again, who comes out and uses words like, cryptocurrencies and crypto assets and distributed ledger technology, means they don't really know what they're talking about. And it's not really fair to you might think to yourself, oh, they're a law firm, they're specialists, we'll just simply leave it to them. No, they don't have a clue what they're doing. And let me just read this notice that Craig put out. This was back in 2020 about that. Again, this is quite famous. He said, long-term advance notice. Again, this doesn't apply anymore. He said, I, or brackets I, plan to sell large volumes of BTC for USD. This will occur on a single exchange as a rolling iceberg order, followed by significant orders of other exchanges. It is expected that the value will drop significantly and will be matched by a 10x leverage short. The network hash will be throttled at this time, limiting all movements to and from exchanges, only spending the unrecognized SegWit transactions to miners and our own exchanges. Transactions will be processed in blocks. All other transactions will be rejected from blocks and will lead to an unspent transaction output congestion. A total of 51% of the BTC network prior to the price drop will be added. That's huge. That's massive. So yeah, they're going to block any other transactions from any non-Bitcoin transactions, which are SegWit transactions, from being able to be made. The sale will align to a reward halving. Once the network adjusts to this new difficulty, the miners should be turned away from BTC. Mined blocks will actively reject and spend all so-called SegWit blocks, as these are a miner gift under the original rules. There will be no further details at this point going forward. All this will be disclosed to ensure all securities and forex trading laws in the USA and UK are strictly abided by. Now, people are saying, oh, you put this notice out and blah, 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 blah. You weren't going to do it and all this kind of stuff. Well, just take a look at him here. This was him at the CoinGeek Live conference. And this was from September 30th to October 2nd, 2020. Now, I actually absolutely knew that he was going to do that. I totally knew he was going to do it. And I thought it was a terrible idea. And I knew that nobody could stop him but me, with the knowledge that I had. So I'm literally just going to read this message that I sent to him. There's a few things edited out just because they're more personal. People don't really need to know the full information in there. But the reason I'm doing this is because I'm saying, for the love of God, reach out to me in this COPA court case. These lawyers that you are using need to understand the legal and lawful significance of SegWit and how you commoditize data, and how you securitize data, as in turn BTC into a security. It's not a copyright issue, it's an issue of maintaining its economic commodity value and contractual credibility. And I guess Craig, being Asperger's, isn't really going to explain this, and I know that nobody else knows this. And also, when you go to court, people think, oh, the judge is neutral. The judge is not neutral. You have three parties involved in here. You have the claimant, you have the defendant, and then you have the judge. And the judge rules and makes decisions based on his own personal interests. And his own personal interests are the City of London and the Rothschilds banking system. Because they're saying, it's the strength of a country's economy that underpins its defense, which is true. You need a strong economy, and the strong economy is underpinned by the bank. So the judge rules in the favor of the bank. They are not a neutral party. So therefore, you need the judge to make sure that they are actually neutral to your case. You need to make sure that they are under their oath and that they've sworn an oath of allegiance, and that they've signed an anti-corruption, anti-bribery statement, so that they're not actually working on behalf of the bank. They need to rule on the evidence that is presented in front of them. This is so important. I cannot stress this enough. I've spent years and years and years researching this. And none of this, no lawyers that you go to are going to help you, because they all swear an oath to the bar, which is the British accredited register, which represents the City of London and ultimately defends the central banking network. And it's not in the central banking network's interest to see Bitcoin succeed, because the central bank runs on securities fraud, as defined by SEC versus W.J. Howico 1946. You need people who actually understand this. Even the best lawyers that money can buy will not help you in this case. My God. So anyway, I'm just going to read out this the letter that I sent to Craig. So this is dated on the 15th of December 2020, when I knew what he was going to do. So I said, "Hi Craig, I've seen this 1.4 million BTC, which represented $26.5 billion worth at the time, of BTC being lined up for what looks like a straight dump. I know you're going to pull the trigger soon. I also know you don't like being told what to do. Blank, 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 blank. I'd very much like you to reconsider. This is based on case studies of both the Christian and Catholic churches. They've become a cesspool of crime and corruption. Jesus would be turning in his grave if he saw what they'd become. Also, Mahatma Gandhi thought he was doing the best for his mother country of India by driving out the colonial British, and yet India became so fractured he ended up being murdered by one of his own countrymen who blamed him for all the turmoil that he'd created. My point is, there is always another chapter in life's adventure that needs overseeing. Just because a war is won doesn't mean there isn't going to be yet another one over something entirely different. Blank, 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 blank. When Bitcoin is revealed as BSV, there will be a minority of BTCers who are so stupid that they will want someone to blame for the turmoil, just like Jesus and Gandhi. Although Jesus, Gandhi and their stories are world famous and written in history, their true legacy leaves much to be desired. When you told me Bitcoin could be divided by 16 or more decimal places, even Shadders seemed unsure about this. There will be many more decisions that require your guidance and oversight. Bitcoin will be written in the history books, but it needs to be written right, and it will need you around to do it. Please change your mind if you haven't already. And that was from me. and that was back in 2020. And because that didn't happen, luckily, we are now here. We are in this court case where a court is going to decide, yes, you are Satoshi Nakamoto. Craig cannot be responsible for popping this bubble at all, because that is what the other side want, and they're purposely doing that so that somebody will, want ill will on him, rather than having the finger pointed at those who actually implemented SegWit, corrupted Bitcoin, meant that it couldn't be used as a peer-to-peer electronic cash system, and it wouldn't be able to economically sustain the network because they're trying to get rid of it. Like, oh my god, like this is absolutely massive. And I cannot state this strongly enough. The best lawyers that money can buy will not help you in this case. And even if you are going to use them, you need to explain to them the economic and lawful significance of SegWit. The fact that SegWit removed all contractual credibility and therefore all economic value from the network, because it's not an argument over copyright. And these lawyers that you're using for the Copa case, they will need to probably put these arguments forward. And if you're only going to use your receipt file, the fact that I bought bitcoin.org, the judge might simply not allow it. Who knows what's going to happen? And it's kind of, if you thought this case was going to be easily won, then you wouldn't have bothered changing solicitors so many times. So please reach out to me. Oh my god. And anybody who's listening that hears my plea, that has contact to them, please get them to reach out to me so we can discuss this. And again, this is all about the largest court case in financial history, the cabal masquerading as COPA, calling themselves the Crypto Open Patent Alliance, versus Bitcoin, which is Craig Wright, the creator and inventor of Bitcoin, on the 15th of January 2024. Stay tuned and we'll bring you more. And until then, be aware, take care, stay safe out there, and we'll see you in the next one.